My name is Geoffrey Care. I'm the former Deputy Chief Adjudicator of the Immigration Appellate Authority, as it then was, and a Chairman in the Immigration Appeals Tribunal, again as it was at the time. I'm speaking today on the expert in asylum and human rights cases with possibilities for use and abuse. Throughout this talk, I intend to use the masculine, but that is intended for ease, to include the feminine, of course. So don't take offence at that. It may surprise you to hear that it's not at all uncommon for immigration judges to take the view that they have no need of expert evidence, particularly when it concerns a situation in a country from which or through which an asylum seeker has come. This view may in some cases be influenced by the fact that experts, either medical or country information, may be difficult to find or too expensive, so that the parties, when it's up to the party to call them, do not produce them. I hope to dispel the reservation concerning the value of the expert and to remind those from the United Kingdom of the protocol for the instruction of experts, which states, "Expert witnesses perform a vital role in civil litigation." As for their cost, this is more difficult to resolve. Sometimes it may prove too difficult. The point remains, however, that in every refugee status or related human rights claim, in every jurisdiction, the issues to be addressed are basically the same. The convention under which a country operates in these matters are similar, though the most common one is of course the 1951 Convention, along with its 1967 Protocol. The other refugee and human rights conventions, such as the OAU Charter of 1969 for Africa, and the regional agreements for Latin America, including, in particular, the Cartagena Declaration, simply expand their catchment areas. For the purposes of this talk, I can deal with these aspects, but I will concentrate on those which predominate, or which are common to all claims. However, the approach can be seen from the medical evidence guidelines produced by the International Association of Refugee Law Judges, and which can be found on its website. Its website, along with all the references, I have attached as footnotes to the hard copy of this talk, and I will not actually refer to them during the talk itself, as it simply confuses the issue, I think. Let me deal first of all with factual evidence. The facts in any claim, whether they relate to medical conditions or the treatment required by the claimant, or the situation in the country to which he may be returned, and where he claims he will be subject to persecution, are usually pivotal factors in every decision. They vary with every claim and every claimant. No two claims are precisely the same. Of course, issues of law arise in most cases, but whilst I would not say that this is the easiest part of the decision-making process, there is usually a precedent to guide the judge, and a right of appeal if the decision goes wrong. On the facts, however, judges will never know if they got the facts right or wrong, because there is no feedback. And what is worse, there is no appeal, generally, from a finding of fact. This is certainly the case in the United Kingdom ever since 2002. In my own experience, I have found that I can only, in the words of Sir Stephen Sedley, a former Lord Justice of Appeal in England and Wales, do my honest best to make what are likely to be life and death decisions extracted from shreds of evidence and subjective impressions. The task is not the same for judges in the usual courts, where the decision in the United Kingdom is based on the balance of probabilities, and upon whatever evidence the parties decide to produce. In asylum and human rights cases, the decision should be based on a search for the truth, and the judge may have to look beyond that which the parties or their respective representatives lay before the court. Documentary evidence of background, country of information, country of origin information, COI, differs from the expert evidence we are considering here, and it is often the only evidence the judge ever sees about the country in question, and he has to rely on that alone. As I hope to show, this can seriously limit the chances for a safe decision. This is despite the fact that the COI may in part at least be derived from the efforts of the very same people who may be called as experts. It's called a crossover in technical terms. Nonetheless, COIs are a device, along with country guidance cases, which is used in the United Kingdom, in the armoury to help a judge struggle through masses of country data. Both have come in for criticism, and both should be approached with caution. Remember, it may not be up to date, or its provenance may be questionable, either unsourced, or it will have its own agenda. For example, a country's own foreign affairs reports and newspapers are bound to be suspect. But nonetheless, this necessarily makes any document not inherently inadmissible or totally unreliable, but the judge will have to consider all the documentary evidence, along with all the evidence, including that of the claimant himself, and decide what weight, if any, to attach to all of it as a whole. The judge will also have to draw a conclusion of the claimant's own veracity or reliability, often conjoined as credibility, and then on the evidence as a whole, not simply on part of it. To add to the judge's burden, there is a recent illustration of the need for adequate resources to enable a satisfactory evaluation of a factual position on which to base an interpretation of legal provisions. And this is to be found in Article 15C of the Recast Qualification Directive. Article 15C reads as follows, and defining serious harm as serious and individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international or internal armed conflict. This provision can potentially affect the outcome of many cases dealing with international protection, and has not been proved easy for judges to apply within different EU member states. There have been reaching divergent opinions on the interpretation of this provision. The best avenue to an understanding of how a country actually works and how different cultures live in practice is through the use of expert evidence. As to the physical condition of the claimant or the type of treatment required, this can only be supplied through a medical report. Some countries recruit their judges from as many different cultures as they can, or even I never want them to abandon their own knowledge. Consciously or unconsciously, they will introduce their own knowledge from their own backgrounds. the judge should not, in this jurisdiction, be afraid of this. Indeed, it may be a substitute for evidence which an expert would give if he could be called. More like the idea of a specialist in Russia. In doing so, however, the parties must be told what is to be relied on so that the parties can respond and a full and fair hearing can be ensured. For the judge accustomed to operating in the normal courts, introducing his own evidence, his own knowledge, is unthinkable. Given the nature of an asylum hearing, however, it is more to be accepted and often cannot be avoided. There are what I would term two myths which I must dispel. Firstly, that the immigration judge is a sort of expert by reason of having handled so many cases so often from the same part of the world. This is a myth. It's a myth for two reasons. I've already adverted to one, which is that the judge never gets any feedback so as to know whether the conclusion which he reached was right or wrong. And secondly, the situation in the countries from which refugees routinely come are inherently unstable. So situations there change rapidly. A long period of building up the background of country information therefore does not make a judge an expert in fact. At most, the judge can learn how to avoid some pitfalls. This should be very obvious, both in our changing world and our limited understanding of the inner workings of countries on the ground. The judge can certainly be expected to become an expert in law and how to handle cases which both are most important. Karl Popper's opinion that we need to be constantly aware of the study of the products, in the sense of what goes into the product, into the production, is vastly more important than the study of the production, the outcome itself. This reminds us that the value of the ultimate decision depends on a proper approach to the steps which are taken on the way to reaching that decision. Now to turn to the actual role of the expert. The primary role of the expert is to lend substance to the claim, and he does so from training, experience, knowledge, preferably though not necessarily gained by personal exposure in the country itself when it comes to country background information. Due to the fact taken by some judges, which I've referred to at the beginning, that they do not see the value in the use of the expert, at least on facts, I need to lay out in greater detail how the evidence of an expert can be in the search for truth, better than a COI. The expert links the claimant and his story to the position on the ground in the country at the relevant time. Documentary evidence is by its very nature general, and it has no particular person in sight. The expert, medical or factual, is called as an independent witness to help the court, and not to give any direct opinion, one way or the other, of the credibility of the claimant. That is the judge's duty on the basis of all the evidence. The expert's duty is therefore to the court, not as partisan to one of the parties, even the one who calls him. The court expects the expert therefore to be objective, but that is of course relative, since it is impossible to expect an expert to have no point of view at all. This could, at times, come quite close to bias, or looking like bias, whether conscious or not. In the case of a medical person, there is likely to have been personal contact with the claimant, either as his doctor or in interview or interviews. And I think that total detachment seems too much to expect. This the judge must recognise and identify, so that a useful evaluation may be made of the evidence which the experts provides. The psychiatrist. Psychiatrist often must come much closer to his subject in order to be able to offer any meaningful opinion, and, for example, may have his own attitudes to such as post-traumatic stress disorders, or the anthropologist may similarly have formed clear views about the aspects of tribal or cultural practices. Or again, a woman's human rights activist is likely to have a gendered approach to a woman who has been raped or suffered FGM. There are differing views upon the needs for and the downsides to interviews with the claimant. Medical evidence must usually be based on what the claimant says, which may have been a written narrative or gained from interviews, especially in psychological situations over a lengthy period of time. Some judges seem to think that this inevitably makes the expert biased, and without further investigation as to the nature of that bias, dismisses his entire evidence. Even in physical matters, a doctor bases his report on what the claimant tells him, as I've said. If this disqualifies such a report, there can never be one which is free. The mere fact that a psychologist must get close to his subject in order to be able to give any opinion of value may colour his evidence as to subjective matters, but it should merely be taken into account, not dismissed. The manner in which the report is given, or some careful inquiry, can often indicate the extent to which the evidence can be and should be relied on. It may be true that in some cases an interview may be counterproductive, and all that can be said is that situations are so variable that no hard and fast rule can be laid down. Thus, in summary, the agenda or bias does not necessarily require the judge to reject the evidence as a whole, render it inadmissible, any more than a single COI document which disagrees with another one will lead to the rejection of the evidence per se. Read collectively, they can often lend considerable weight and enlightenment to the judge's overall understanding of the position, especially is this the case when it is only COI information along with the claimant's own evidence which is available. The expert can provide first-hand, up-to-date knowledge of the matter on which he is giving evidence, either from the interview or close studies, and is likely to have a greater insight into the realities in relation to the claimant or someone in the claimant's situation. He should be able to provide details about what the position looks like on the ground and give the judge a more accurate picture of the realities of the claimant's own story. And this is important as the element in assessing the applicant's, the claimant's own credibility. And it is indispensable for any prognostic assessment which may be at the heart of a decision. Some guidance may be necessary on how to approach country evidence as a whole, and of course it's also helpful to have guidance on medical evidence, which I have said can be found in the guidelines which are on the IRLJ's website. Cultural milieu religious practices, ethnicity, language, geography, topography, and the history of a country are usually needed. COI can achieve much of this, but an anthropologist with experience in the region under scrutiny is usually in a better position to provide more helpful evidence. He can contextualize the evidence, as it were, and even may be in a position to evaluate the COI evidence which is produced as well, even if he didn't actually be the one who produced it. A sound assessment of the political scenario or conflict analysis or the security situation of different parts in the country in relation to different people, how the national laws, the judicial system, the law enforcement affects them, and how this operates all in practice. Additionally, the extent to which basic human rights are respected in practice, and how the authorities in the country of origin are able and willing to offer protection against violations, can all be better related to the claimant's own position as an individual in the report of an expert witness. Turning next to who is an expert and who calls him, different countries use different terms for the person we call in UK an expert, and we need to be aware of this. For example, Russia draws a distinction between an expert, the criteria for which is defined in legislation, and a specialist, who could be anyone, family friend, member of a particular community, or, as I've said, could be the judge himself. Scotland uses expert at times, but the rules are different from England and Wales. The most startling difference is that in Scotland, expert evidence can only be given by oral testimony, while in England and Wales the giving of oral testimony is rare. Furthermore, in England and Wales, the expert's written report is his evidence in chief, whereas in Scotland, it serves only to give advance warning of what his evidence will be. In the UK, the pre-trial exchange of reports achieves a similar purpose. Thus, the expert report of the UK is addressed to the court, to whom the expert owes his overriding duty. The practice of whether it is a party or a court to call an expert witness varies from country to country. Where it is the court, then the court pays for it. That is the situation in the Netherlands. In others, it's up to the party to call one or not, as they wish. I cannot see why a judge who decides that he cannot reach a satisfactory conclusion without an expert, medical or factual, does not have the right and perhaps the duty, if he thinks justice requires it, to call an expert. Given the nature of the inquiry, given the nature of the difference between an ordinary civil case and a decision which has got to be reached in a search for the truth as a whole. But if the judge is going to do this, then he's got to take steps to ensure that the hearing is fair to both the parties. That is, as I've indicated before, that they have the duty to consider it and question it. To give some idea of how practices vary from country to country, and perhaps therefore a need to have some basic guidance, given the convention under which we all operate is essentially the same, some examples follow. In South Africa, certain facts are accepted knowledge from the media, or in country information, or even through the judge's own investigations. In France, experts can be commissioned by a judge but rarely are. The applicant calls them. Again, in Australia, it is to commission an expert, unless it is rare to commission an expert, unless it affects an issue or theme of a group of claimants, or if there are divergent opinions upon what's happening in a particular country. Somewhat on the lines of the United Kingdom's country guidance cases, which have been looked at as a whole by an upper tribunal. Strikingly, in Australia again, a minister can give a binding direction that the judge must give regard to information issued by the Department of Foreign Affairs, even where the papers themselves are not sourced. This may be in conflict with better sourced expert opinion, said one judge, but we still have to give preference to that country information. In the United Kingdom, this would be regarded as a fundamental compromise with the independence of a judge. The judge must be prepared to reject any imposed conclusion to be drawn either from a set of facts or anything else which he himself, on a consideration of the evidence as a whole, thinks does not fit that case. Canada, written reports are commonplace, though occasionally an expert is present in court. The evidence may be in a report, an academic journal, an article or a book, and is commissioned by a claimant. Recognising the difficulties in finding suitable people as experts in different fields, attempts have been made to create registers of experts, which can of course be of help. But merely because someone is on a register does not mean to say that the judge will, after due consideration, accept him as such. In the United Kingdom, the Electronic Information Network, EIN, has created a directory of experts, and the UNHCR, RefWorld, provides a list of COI experts. Turning to matters to be considered before accepting someone as an expert, any assessment will apply basically the same tests, namely, firstly, who produced the information and how and for what purpose. Secondly, whether the producer is independent and impartial. This has been addressed above. Thirdly, whether the producer has established knowledge, that is, qualifications, writings, and acceptance in his field, membership of professional bodies, time in the field itself, and so on. Fourthly, whether the information is couched in suitably objective tone, that is, without overstatements. And fifthly, whether the scientific methodology has been applied and whether the process has been transparent. Any standard opening paragraph to any report should at least include the expertise of the witness and a signed and dated statement indicating that he understands his duty as an expert witness. And on this, one will find confirmation in Supreme Court rules in England and Wales. There are some differences in approach to medical as opposed to country background factual information. I've tried to deal with matters which by and large apply to both. However, an important provision which relates to medical evidence emphasises the major requirements of this type of expert evidence. Though the 6 markers which I am setting out and will give you in a moment are not completely irrelevant even in other expert evidence, as should be fairly obvious. The Istanbul Protocol, in paragraphs 103 and 104, provides guidance in medical examinations with the assessment of the need for treatment and a psychological evaluation suggesting these 6 questions which any medical person should ask and the judge should look at. Firstly, consistency. Consistency in physical and psychological findings. Secondly, the physical conditions in the clinical picture. Thirdly, the context of the claimant's own cultural, social background and findings, whether they are expected or typical reactions to extreme stress. Fourthly, in relation to torture, timeframes are important. Fifthly, whether there are any other stressful factors, and if there are, then what their impact is or may be. Finally, does the clinical picture suggest an allegation, for example, of torture, as being true or false? As to some aspects linking the country to the claimant's story, turning back to factual background information, the anthropologist can be invaluable, as I've said, in contextualising the evidence. It renders credibility, I've said before, less problematic. I re-emphasise this because credibility is almost a mantra, and one must take a good deal of care over that, given the fact that the most experienced judges in most jurisdictions are very wary of claiming any form of infallibility in being able to tell whether someone is telling the truth or not. However, in my experience in Africa, even an expert, an anthropologist often, who is a native to the region, can seriously misrepresent the position in matters, for example, of language, usage, as indicating where the person came from. An additional matter which arises in experts' reports on whatever subject is the question over the use of the report which has been given for other purposes in an earlier case. Primarily, it should not be used, at least without the consent of the producer, but even then, its relevance to the case in hand, whether the conditions have changed and so on, often render it of little use. Safeguards can be found in guidelines I've mentioned and in other guidelines produced with much thought, but they're only guidelines. Then, to the weight, I've drawn attention to distinctions between inadmissibility, wholesale rejection, and something less. Acceptance, subject to an evaluation of the weight to be attached to the evidence. Once someone is qualified as an expert, using the criteria suggested, it implies that their evidence will be given the appropriate weight in the proceedings. Their opinions cannot be ignored and may be crucial in the determination of the claim to refugee protection. If the decision makers wish to discard their opinion, the expert opinion, then they're obliged to say why. For instance, if the opinion evidence of the expert contradicts the overwhelming evidence from various reputable sources, then on balance, one must decide whether the expert witness's evidence outweighs the combined effect of all the other evidence. Likewise, if there is no other evidence presented, save the qualified expert's evidence, then does the decision maker simply adopt the opinions of the expert? How does one properly assess and weigh contradictory evidence presented by two experts? It's difficult, and I cannot provide an answer. Each case varies, The judge will simply have to do the best he can, as Stephen Sedley said. Some common problems and some solutions may be offered. I've alluded to some of the problem areas a judge will encounter in fact-finding and how to deal with them, such as the use of one's own knowledge, early reports. As to the availability and cost of experts, where the judge considers expert evidence as necessary, but none is available for one reason or another, one possibility is to widen his search for documentary evidence, even to sources outside his own country. And perhaps he may be more ready to give the claimant the benefit of the doubt. Where there are conflicts which cannot be reconciled between different parts of the evidence, consideration should be given to cases in other courts, where the same or similar evidence has been either accepted or criticised. Guidelines, practice, policies in other jurisdictions, or the European Court of Human Rights may sometimes assist to resolve an inconsistency. The Handbook on Procedures and Criteria for Determining Refugee Status under the 1951 Convention and the 1967 Protocol produced by the UNHCR, paragraphs 203 and 204 are of significant and important assistance. If the case hinges on membership of particular social group, an expert may be considered too close to the claimant for his evidence to be considered independent. Perhaps the only way to overcome this is to accept it, but give careful thought as to how much weight it can be afforded. Finally, at the end of the day, the judge must reach a decision based upon a holistic view of the evidence as a whole and doing the best he can to resolve the inconsistencies. Thank you. Thank you. Okay.